Hi, my name is Loren Locke. I'm an immigration attorney in Atlanta. Let's talk about what next after your petition was denied. And specifically, I'm focusing on EB1A, but a lot of this applies to multiple categories in USCIS in the employment-based realm. When your petition is denied, I'm assuming your status right now is good. It's a whole other topic if it's a non-immigrant status that you're depending on to be in good status right now. If we're talking about a green card process, your I-140 petition got denied. You're not in an immediate emergency, but you're left wondering, what do I do? A lot of people look at that denial notice and they say, oh, it gives me the chance to appeal. It gives me this 33 days to do it. It tells me what to do. Like, that's what I should do. I think in most cases, an appeal is going to be a massive waste of your time and money because the chance that you're going to get the decision changed through an appeal is really low. Well under 10%. I think that you'd actually be better off if you just filed your same filing that you used before and don't even make any improvements. I think your chance of winning on the next time will be better than 10%. So that brings me to what I do think you can do, which is sometimes the mix of the easiest lift and the most effective is you've probably got an RFE or a notice of intent to deny before you got denied. So you probably already brought together new evidence, thought hard, boiled together something, put your best foot forward, and you still lost. But now you've got that initial filing and you got that filing, that secondary one that was the response to the request for additional evidence, or it was the response to the NOID. So you've got a lot to work with. And here's your chance to reformat it into something new and better. Sometimes it may not even necessarily need to be better. Just because you've lost doesn't mean your case wasn't good. You failed to convince one person to approve it. That doesn't mean the next guy or lady wouldn't have approved it. So you can try again without really making any major changes. Or you can take this opportunity to make whatever changes you want. Lately, I've been really into stylistic and formatting changes because I really believe that our old school way of doing it with a really lengthy, really detail-rich, long-form letters is not working for today's adjudicator. They don't seem to be paying attention enough. And I really don't think that even though they get a lot of money in our filing fees, they're not using that money to staff in a way that they can look through your filing at a leisurely or even comfortable pace. They are in a hurry. They don't need to say yes to you. They don't get any blowback if they say no. If they're feeling confused, maybe they're feeling confused because they found it boring. They kind of skimmed it and it just ultimately it's not resonating with them. If that's your life's work, it's really insulting. First of all, I acknowledge that. It doesn't feel fair. It feels that since you paid them so much money, especially if you paid an extra $2,800 for premium processing, that you really deserve their careful attention. And I think a lot of people mistakenly believe that you purchased their careful attention and so you got it. I don't believe that at all. No matter how much money USCIS is raking in, it's not like the adjudicators are getting paid per case or getting paid more if they work harder or have different kind of results. There's a real separation in the public sector between money and the work that I think a lot of people that are working in the private sector don't really understand. Like, a lot of work in the private sector is explicitly for profit. And so you're used to the idea that if I'm more efficient, if I do better, if my work is better and I get more of it done, the company will make more money and that will help me. Maybe I'll get a bonus. Maybe the company will raise everyone's salary. Maybe it'll make the company more secure and I'll just keep my job. That's not really the mindset when you work for the federal government. It's always been like, well, I'm getting paid and what I do isn't really affected. Like, my pay and how hard I work are not closely correlated. My pay and the results of my work, it's not correlated. If I adjudicate twice as many cases, I'm going to get paid the same anyway. I'm going to work really hard. I'm not even allowed to work hard because I'm probably not allowed to do overtime without special permission and make sure that it's in the budget. But But just because they collect a lot of your money does not mean they invested in your case. It does not mean they read your case. So when your case loses, it doesn't mean that that's a total indictment of everything you filed and your career. You could actually just refile it and win. The other thing I'm going to talk about separately is appeal is a waste of your time. Refile might work. It's really worth considering. Or you could go into federal litigation if the beneficiary and the petitioner both want to do it. If a company sponsored you, you can't do it on your own when you're the beneficiary and you lost. Litigation can really work, but a lot of it's something to proceed with caution, but it can really, for the right case, it can reverse your results in a hurry. But it's another whole can of worms. Thanks.